The United States Supreme Court issued a decision on January 22, 2019, affirming the invalidation of a patent that was filed more than a year after an agreement was entered into by the patent owner to sell the product covered by the patent, even though the agreement expressly required the purchaser of the product to keep all technical information about the product secret. The case, Helsinn Healthcare SA versus Teva Pharmaceuticals USA, Inc., serves as a reminder that if you are working on a deal to sell or license technology, when you file a patent application relative to when you enter into the deal can be absolutely critical to preserve patent rights. The rule of thumb here, at least insofar as the United States is concerned, is to make sure you file within a year of when you enter into the deal, and ideally to file before you enter the deal so as not to jeopardize any patent rights outside the United States. The key facts of the case are as follows. Helsinn Healthcare, a Swiss pharmaceutical company, makes Aloxi, a drug that treats chemotherapy-induced nausea and vomiting. Helsinn acquired the right to develop palanositron, the active ingredient in Aloxi, in 1998. In early 2000, it commenced clinical trials proposing to study a 0.25 milligram and 0.75 milligram dose of the active ingredient. In September 2000, Helsinn announced it was beginning phase 3 clinical trials and was seeking marketing partners. MGI Pharma, a Minnesota pharmaceutical company that markets and distributes drugs in the United States, entered into 2 agreements with Helsinn, a license agreement and a supply and purchase agreement. MGI agreed to exclusively purchase from Helsinn any palanositron product approved by the FDA, and Helsinn agreed to supply MGI as much of the FDA-approved doses required. The agreements included dosage information and required MGI to keep confidential any proprietary information received under the agreements. Nearly 2 years later, Helsinn filed a provisional patent application in the United States covering the 0.25 milligram and 0.75 milligram doses of the active ingredient. Over the next 10 years, Helsinn filed 4 more patent applications claiming priority to its provisional patent application, the 4th occurring in May 2013, which issued as United States Patent Number 8,598,219. Notwithstanding that the agreements governing the sale required MGI to maintain the technical aspects of the invention secret, Teva argued that the 219 patent was nonetheless invalid because it was on sale more than a year before Helsinn filed its provisional patent application. The Supreme Court agreed and explicitly held, quote, an inventor's sale of an invention to a third party who is obligated to keep the invention confidential can qualify as prior art, unquote. This case serves as an important reminder that so-called secret sales can invalidate a patent if they occur more than a year before a patent application is filed. Before you finalize any deal to commercialize technology, you should check to see whether a patent application covering the technology has been filed. If you have entered into such a deal and haven't filed yet, you may have up to 1 year in which to file in the United States. A link to the Helsinn decision is provided with this post. Thanks for watching and have a great day.